to AmeriCollect's webinar, Calling All Cell Phones with Express Permission, of course. My name is Nick McLaughlin. I'm a member of the sales and marketing team here at AmeriCollect, and I get to be your administrator for today's webinar. If you have a question at some point throughout the webinar, type it in the question box, and we'll be happy to get back to you immediately after the webinar. Feel free to shoot us an email as well. We're happy to. That's sales@americollect.com. Now on to our presenter. Kenlon Gretz is the president and CEO of AmeriCollect and has been with the company since 1988. He loves pina coladas, long walks on the beach, and taking great care of our clients. So Kenlon, take it away.
Thanks, Nick. I appreciate it. Pina coladas and long walks on the beach. I'll just take a warm summer at this point. My goodness. Happy summer to everybody. 2 days into it, or 2 or 3 days into the summer season, but it feels like it's still spring here in Wisconsin. So thanks for joining us. We got a big crowd for this. Calling All Cell Phones with Express Permission. That's who I am, the president and CEO. Hey, we're celebrating 50 years in business here at AmeriCollect. It was started in 1964. I was lucky enough to buy the company in 1999, and I worked here since '88. So we continue to offer these free webinars for our clients and non-clients alike, and hopefully you'll get something out of them. So let me start. First off, I want to let you know that this is not legal advice, but this is kind of the email blast that I sent out. The largest health system that we know of is being sued over a TCPA class action lawsuit. And so this was something that I'd sent out a while back. We'll get into some details of it, just a little bit. But this class action lawsuit is interesting. Tenet Healthcare owns a company called Conifer Health Solutions. Basically, they're an extended business office that makes outbound phone calls that are first party. That means they're in the name of Tenet Healthcare corporations, and they make outbound phone calls, reminding patients about the money that they owe. And so I even have a copy. One second, I'm going to pull this down here, and here's the lawsuit itself. It's Shirley Freeman versus Tenet Healthcare versus Conifer Health Solutions. It's a class action complaint. It's only 18 pages long and double-spaced. Here's how easy it would be for this law firm to start an action against your organization. They would hit find, Tenet, and they would hit replace with your healthcare name. It's that simple. This case is really interesting in the sense that Shirley Freeman is the wife of the person that owes the money. She's the wife of the person that owns the money. The husband's name is William. Of course, this is all public record, so I'm not explaining anything. So the husband's name is William. He had a bill with one of Tenet's hospitals, and he didn't pay his bill. So what happened was the organization made some outbound phone calls. In fact, on page 5, it has actually the message that was left on his answering machine. And it said something like, one second here, I believe it's on page 5. The message basically said, I think I missed it. The message basically said that, hey, this is the particular hospital. Please give us a call back. It's not an emergency. It is a organization that just wants you to give them a call back. Oh, here it is. The business office for Spaulding Regional Hospital calling for William Freeman. Please return our call to the 800 number between 8:30 a.m. and 5 p.m. Please note this call is not related to any medical situation. Now, the reason they're getting sued is because William Freeman, that phone that they called doesn't belong to him. It actually belongs to his wife. That's how ugly the TCPA is. I'm sure that he probably gave the phone number, the cellular phone number, or maybe she was at the registration desk and gave it to the consumer or to the hospital. That's how ugly this is. And again, the cost of defending this is huge. They may not be guilty here. Maybe she did give permission to have them called. Maybe he gave permission of his wife's phone. The key here is that we want to start protecting ourselves from these kinds of lawsuits, and that's what we're going to talk about today. How can you build a defense to keep class action lawyers away from you regarding the TCPA? This is Additionally, Freeman alleged that while she doesn't know how tenant obtained her cell phone number, it seems likely that tenant improperly obtained it from either a third party or the emergency medical contact portion, the next of kin, or whatever you want to call it in your organization. They were calling this gentleman's wife for his bill. And I think about how cell phones work. That happens all the time. So that's the basis of what we're talking about today. Again, this is not legal advice or contract wording. So just some information regarding cell phones, how important they are. 91% of Americans own a cell phone. 91%. That number keeps moving up like you wouldn't believe. 81% of them send or receive text messages. You know, they above and beyond using it for a phone. So 81% of them. This is the percentage of adults living in wireless-only households. 65% of consumers ages between 25 and 29 don't even have a landline. 59% for the next category. An amazing number of people have no landlines. It's really getting to the point where this is the only phone number that we have to contact consumers. We did a study for 3 of our separate clients. One of our clients, 54% of them had a cell phone in the first phone location on their system. That's another big question that you're going to have to ask yourself is, where do you store these things? You know, do you store them in a phone location called work, home, other, cell? And if they're in cell, you know, in a cell phone location that it's labeled on your system, does that mean you have the authority to call it? There's a lot of questions here, and we'll get to some of the basics. But on your system, I mean, what percent of them are cell phones? If you'd like us to do a test for us, we'd be happy to. If you export a file for them, we'll run a test for you. We use a scrubbing service I'll talk about in a little bit. That's my oldest daughter, Hannah. She's 19, and my youngest daughter, Kira. You know, they've grown up with cell phones. Our rule in our household is you have to be in 8th grade before you can get a cell phone. But that's not the rule all the way around. Of course, there's other families that kids are in 5th grade and 6th grade and have cell phones. Remember what this case is about with the tenant. It's that we called, or tenant called, the wife on her cell phone. Every one of my children, I have 5 daughters, they're not the subscriber of the cell phone service. My wife is, because we have this big plan. We have this big cell phone plan. So think about that. What's this going to cause, the pain that it's going to cause down the road when we think about how everybody has cell phones. I would imagine that Hannah will still be on our cell phone plan until she's 25 or 26. You know, we'll just either give her the cell phone expense for a Christmas present or something like that. But she won't be the subscriber. She won't even be the subscriber. What if Mr. Freeman there really used that cell phone, but it was listed in the name of his wife for that purpose? So a lot of complexity here. We'll talk about it. We did a survey a while back. Okay, this is a collection agency survey. We made outbound phone calls, and so we surveyed only people that said, if we were looking for John Smith, only people that said, yeah, I'm John Smith. 77% of them said that they had caller ID. 75% said they looked at the caller ID before picking up the phone. 90% of the consumers who picked up the phone didn't know it was us calling. I want you to think about that. Outbound phone calls are important. People pick up the phone no matter what the caller ID says. So the outbound phone calls, people are picking up. And most of the people didn't know who they were answering to. Inbound phone calls that were returned. These are inbound phone calls from people that are a right party, people that we wanted to talk to. 75% of these calls came from left messages. There's a lot of question about, well, should we even be leaving a message? If you don't leave a message, they're not going to call you back. Can you afford, or can your collection agency afford not to leave messages if 75% of the return phone calls come from a left message? Now, let's dig into that 75%. Of the 75%, a little more than half, 53%, actually listened to the message. They actually listened to the message and returned our phone call. The other, or 33% of them, just hit return dial. They didn't listen to the message. They just said, oh, I missed a call. I'm going to call them back. And then of the other, the 14%, which is the remaining part, returned the call because somebody left a paper note with a message to call them back. So that's an old-fashioned landline answering machine. Again, we didn't do this study with just whether it was a cell phone or not. We're working on one for this year. So you think about this, 75% of all calls came from a left message. Messages are important. They are important. They generate a lot of revenue. Here's some inbound calls returns right party. The 25% that called us with no message, they called us either because they got a notice from us or there was a no answer from their caller ID. Their voicemail didn't pick up. They saw our phone number on the caller ID. Of the 61% of the 25 said they knew it was AmeriCollect they were calling. We expect that to mean that they had a notice in front of them. But again, that means that the rest, 39%, just returned the phone call by hitting return call. They didn't look at the caller ID. They just said, oh, I'll call this person back. It's a missed phone call. Or maybe they looked at but they returned it back. Again, the whole point about my statistics here are to let you know that making phone calls generate revenue, and making phone calls are important. You have to ring the phone. Again, 75% left messages and 25%, or 61% of the 25 knew it was AmeriCollect. That's amazing numbers to me. People do call people back when you're ringing their phone. So the Telephone Consumer Protection Act of 1991. 1991 prohibits the use of any auto dialers and predictive dialers or an artificially or pre-recorded voice call to be placed to any wireless number except for emergency purposes or with the called party's express consent. In 1991, this law was meant to tackle telemarketers with the intent that their systems would be hard-coded to dial an area code, a phone number, and as I have in the bottom example there, 111 or 312-111-112. That's what the law was prevented. That was the intent of the law. That was the intent. Of course, in 1991, nobody really thought about how much cellular phones would explode. 91% of the people in the United States now have them. No one thought much about, how we utilize cell phones to remind people of important things in their lives. The penalties for violating this act. So I want to be clear that you can manually dial a cell phone all day long. You can pick up a handset and dial whatever number you want to. You're not violating anything. You're not violating a single thing by doing that. But the penalty is $500 per phone attempt. We're not talking about the ones you just reached. It's if you rang their phone. Or $1,500 for a willful violation. Now, the willful violations is completely just ignoring the law, but that's where most class actions start. They say that everything is willful, that they had the ability to determine whether or not there was express consent. So they start off at the $1,500. One of the things that I want people to realize today is that this is bigger than just once in a while. Although in the USA, too, it was about a week or so ago, I see that the Kohl's Corporation got sued for making phone calls to people that owed a $20 bill. They're involved now in a class action lawsuit. And these class action lawsuits right now, they're hitting the big players because there's a lot of money there. But eventually they're going to start hitting everybody. Local lawyers that dabble in class action lawsuits are going to start figuring out that, hey, this is a huge profitability for them. If you're not familiar with a Google alert, I suggest that you set one on your Gmail account. Google alerts come up in your email every day. I've got several set on TCPA and TCPA class actions. If you want to get sick to your stomach about this law, set a Google alert on TCPA class action, and every day you'll find throughout the United States there's companies getting sued for $4 million, $5 million, $3 million. If you set it underneath just TCPA, you're going to find a ton of small cases where consumers are suing businesses for $1,500 a phone call. You need 4 phone attempts. That's easy money. That's easy money. That's for 4 phone attempts to my phone number, and it was a willful action. I just made $6 grand off of this company that I don't really care to do business with anymore. Set a Google alert on TCPA and forward these emails to your law department or whoever is representing you, saying, hey, listen, we need to do something to protect ourselves from this. We definitely do. The first thing that shows up in my email inbox in the morning And I read most of them. And it's amazing. There is a ton of activity. The American Collectors Association, I got a statistic from them, the percent of TCPA lawsuits has jumped by 582% from 2013 to 2012. 582%. These consumer lawyers have figured out that this is just a heyday for them. And until we get something changed to protect ourselves or get this law updated to make it more like it's 2014, they're going to start nickel and diming. They're going to start nickel and diming, and then eventually you're going to be involved with a big class action lawsuit. So the TCPA allows you to transfer cell phones to a business partner as long as the cell phone was obtained at the time the credit was established, or if you have express permission later on. So let's talk a little bit about that. So you can transfer the phone number to a collection agency or to an extended business office. That's not a problem, as long as it was obtained at the time the credit was established, so when someone becomes a patient, or if you have express permission later on. Express permission is simply this, is basically having them give you the cell phone number. That's what it is. So it's a pretty simple thing to do. Here's where you can't transfer those phone numbers to us. If you're using a skip tracing service, or a company that, or maybe someone in your organization looks up phone numbers on the internet, maybe they use a company like LexisNexis or a credit bureau or something like that. And if you grab a phone number off of that kind of information, you don't have express permission. They didn't give it to you. You got it from a different source, a third party, and then you transferred it to us. So we need for our clients to realizing that the days of skip tracing for phone numbers need to be over, because you don't have express permission on those. Or if you're going to do it, you need to clearly identify to your business outsourcing partners that, hey, you got this from a different source. You got it from a different source. Another place you can is updated from next of kin. So if you're transferring next of kin or emergency contract phone numbers to a collection agency or to business, you can do it, but you just need to make sure that it comes over in an easily identifiable field or location, that it says this is emergency contact. What we do with our clients that identify those next of kins is we make sure that those are not automatically dialed, that those are manually dialed. So, but I want to repeat, a business partner can always manually dial a cell phone number, and then they can ask for express permission. And we'll get into a little bit about what that sounds like on the phone call. It's not super detailed. It's just saying, is this a good number to reach you at in the future? You say, well, you know, as a healthcare provider, we don't have a dialer. I say to yourself, really? Because these lawsuits are starting to name, as in this tenant one, they named the business outsourcing partner and they named tenant, not just because tenant owns Conifer Business Solutions or whatever they were called, not just because of that. So they're going to start saying, you know what, let's go after either, you know, the small collection agency, let's go after the large hospital. So what are your business partners doing with those phone numbers? What are you doing with those phone numbers? And then I want you to think about all the things that you get reminders about that are really done through a predictive dialer. School closings. I know my school does a great job. You know, I get a voicemail from the principal saying that the schools have been delayed or called. I get that call at like 5:30 in the morning, and I appreciate that call. But imagine a class action lawsuit against a school for calling maybe a wrong number who got that message. Or maybe your utility sends you text messages stating that there's outages in your area. And then they send you another text message telling you that the outage is going to be complete in an hour or 2 or 3. And then I think about your types of, or maybe that your product is ready, what you ordered from Sears, or you have something you can come and pick up. Or maybe you do appointment reminders. Don't forget about your appointment next week, Thursday, with Dr. So-and-so. So these reminders are all across the board. People utilize cell phones all the time. So do you contract with companies? I bet you do. If you don't have express permission, you put them at risk and therefore drive up the cost of doing business with that outsourcing partner and therefore your expenses. I know all of our healthcare providers that we represent, they want lower commissions. And we have the tools to do that. We just installed a brand new dialer this year. So that's already set and going. It's beautiful. It does a lot more than our old dialer, but that costs money. But we also are using more efficient ways to contact consumers. So express permission is just simply having the patient give you a cell phone number. But it's not good enough. The best is to have it in writing. You know, you can document that they gave you the phone number, but that's going to be difficult. That's going to be real difficult. Here, I'll give you one. Papa John's International agreed to pay $16.5 million in damages to resolve a class action lawsuit. See, texting is covered by this too. So if you don't have permission to text someone, you can't text them. So the CCPA covers that. It also covers faxes too. You can't just blast fax and then send it off to people. But get this. Effective October 16 of 2013, it prohibits companies from contacting consumers with telemarketing phone calls or text messages without prior express written consent. That means that I have to click either I agree or that I have to sign something that says this is okay for you to do this. And as a healthcare provider, you say to yourself, I'm not marketing at all. Really? I think you might be. My wife gets phone calls. Don't forget about your yearly exam. Tell me that that's not a telemarketing phone call. Are you trying to get business out of it and have her come back to your healthcare organization for this yearly exam? You bet it is. And then, I might look the other way and say, a class action law firm is not going to look the other way. They're going to say that's a telemarketing. Even a reminder that you have an appointment coming up. That's a marketing phone call if you ask me, because if you do show up, you're making money. If you don't show up, you're not making money. Prior express written consent for telemarketing companies. Now, when you're making collection calls, I would say that they've already bought the product, right? So I just want to be clear here. Express consent, meaning that the consumer had to give you the phone number, is important. But I think it's even more important now with the big October 16th, 2013, not that far ago. The class action consumer lawyers haven't got to this yet. They haven't named anybody regarding the written consent. But they will be. Trust me. In 2008, the FCC clarified that a consumer who gives prior express consent to a creditor similarly gives such consent to the debt collector. This was a specific ruling that they did clarifying it. What we're missing here, the FCC has this well within their hands to write clarifications, and they're not. They're just letting this thing fester. Now, the American Collection Association is doing a good job putting the heat on, but we need healthcare providers to put the heat on too, to be honest with you. This is something that the FCC could solve this in a couple of written clarifications about who they're trying to go after. It's interesting. It's very interesting. So what should you do? Update your admission contracts giving you permission to use text, emails, phone numbers, and cell phones. Don't make this just about cell phones. This is about everything. Because you know what? There's going to be some other loophole somewhere along the way. It's a class action defense. It only takes one named plaintiff, Shirley Freeman, on behalf of her husband, or not even on behalf of her husband. One person. That's all it takes. Somebody that says, you know what, I'm going to get rich off of the XYZ healthcare provider, and I'm going to start this law. It just takes one person. When you do put this agreement, make sure that you don't hide it. Tell people, hey, listen, you're agreeing that we're going to be calling you at this phone number here. That way, when they do get maybe a phone call from a class action attorney saying, did you give them permission? They're going to say, no, I did. They're going to say, yeah, I did sign something that they could call me. And then my question to you is, express verbal consent, permission? How would you prove that? How would you prove that that patient gave you that phone number somewhere during the communication? How would you prove that? That would be very difficult to prove. Where did you get the phone number? Well, I had to have gotten it from the patient. Where else would I have gotten it from? Could have you searched the internet for it? Yes. Well, I guess we could have, yes, but no, it's important that you have a way to prove that you have written permission. Written permission is the way to go. I'll show you. Imagine the cost. These are phone attempts at $500 per violation. Or $500 per violation. Even 4,000 phone attempts are going to cost you $2 million. If it's willful, then it's $1,500. That's $6 million. When you think about this, and think about your organizations that you partner with, I mean, 4,000 phone attempts, that's nothing. That happens in a half a day here at AmeriCollect. 4,000 phone attempts, $2 to $6 million. We need this, and you need this, to get this in your contracts. Do you even know how, if your errors and omissions insurance would cover something like this? How much would they cover? Where does it, a lot of E&O insurances cap out fairly early on class action lawsuits. They don't want to be involved. They don't want to be involved. And do they even cover class action lawsuits? Be aggressive in your wording for the use and acquisition of this data so that you don't end up in a summons and complaint. You know, share with them that you're only going to share it with your responsible business partners. You're not going to sell off their phone numbers. Nobody wants you to do that. And you would never do it anyway. Be aggressive. So here's some sample wording. If at any time I or a person I'm responsible for provides contact information, I'm going to hit every one of these red sections here because it's important to have it. This is a perfect example. So imagine it's a situation where I take my daughter, who is 17, to the hospital, and I give my phone number to her for her account. But imagine 2 years, she's now 19, and my phone number is still, my cell phone number is still in your system as the right phone number to be calling. So that particular wording is about this. If at any time I or a person I'm responsible for, so that you can't be sued backwards for if that phone number maybe belongs to somebody else. So that's important. A wireless or landline telephone number, address, or email. Why do I have landline in there, and why is it bolded in red? Because people port their landlines and convert them to cellular phone numbers. This is one of the most difficult things when you're trying to scrub for cell phones. Was that phone number once a landline and now a cellular phone number? There are all types of scrubbing services, and so I'll get into more detail in a little bit with that. Some of them don't have the complexity to know that it once was a landline and is now a cellular phone number. So it's important to address that. So at which I may be contacted. I consent to receive communication in any manner, including but not limited to automated emails, voicemails, written statements, text, auto dials, and pre-recorded messages. So I'm laying out everything. I'm going to update my emissions agreement one time only, which could result in charges to me. Now we add the charges to me because there have been a few cases out there, mainly FDCPA cases, that have said that under the FDCPA, a collection agency can't cause expense to a consumer. So it was written for collect calls. Collection agencies could not do collect calls. And about 50% of you on this conference call webinar probably are saying, what's a collect call? Somebody else will explain it to you. So add that wording in there. So that if at any time I provide contact information of any type, landline, emails, a physical address, I may be contacted. I consent to receive communication in any manner, including but not limited to. We don't know what the future is going to be like in any manner. Maybe there's a new technology out there 4 years, 5 years from now where, you know, I don't know what that would be. Video call. I mean, a video call. That's not that far out. We already have it. None of us are using FaceTime to communicate with people, but it could happen. or Skype. That's why I'm saying is this wording has to be very future thinking so that it covers you well into the future. Be aggressive in your wording. This healthcare provider may pass this right on to its successors and assigns and other medical providers used during the course of treatment. That one is big, especially for you radiology, pathology, and lab companies that are on this call. You need to make sure that you are covered. You need to make sure that you're covered in that hospital provider's agreement. Affiliates, agents, and independent contractors included but not limited to servicers and collection agents. Make sure, yes, the FCC has made a clarification that it's okay. Why not get it in a written statement? That way there's no questions later on. The FCC could change and flip their ruling. But here, you've got a written agreement. This contact information may be used for treatment, payment, and operations. You all recognize that. That's a HIPAA deal. I acknowledge that I'm an authorized user of this contact information, that I have permission to use said contact information from the actual current subscriber of the information. Now, that's a big one. I acknowledge that I'm an authorized user. Again, as I talked about, my wife, Lynn, she is the subscriber to every single one of my daughter's phones, every single one. And as they get older, 18, 19, it's probably still going to be in her name as a subscriber. But I acknowledge that I'm an authorized user of this. If they're giving it to you at the point of service, they're acknowledging that they're an authorized user. It is my responsibility to update this healthcare provider with new and updated contact information, and that if I fail to update this information, I will hold the healthcare provider harmless for untimely notifications. It's the patient's responsibility to tell you that they have a new phone number. And a lot of that is about tests coming back. How will you be delivering test result information 2020? It's their responsibility to give you the correct information. What's important is this last part here is that you understand that I can change my mind. What's happening in some of the FCC commentary, it's not a ruling yet, is that they want a patient to be able to change their mind and say, I don't want you to call me on my cell phone anymore. And you know what's interesting about the FDC or the TCPA? All that needs to happen, if that consumer doesn't want to get any more phone calls, don't they simply have to call you up and say, please do not call me anymore? And I would say that 99% of my clients would honor that. We as a collection agency have to honor it under the Fair Debt Collection Practices Act. Instead, what we're seeing in a lot of these court cases, they'll go and contact a consumer or lawyer about a lawsuit, and they'll say, is the collection agency calling you? Yep. Good. Document every phone call for the next 6 months so we can build an even bigger case. And we'll wait 6 months because maybe they'll have called you 100 times. So 100 times $500? That's a pretty good investment for just waiting back and doing nothing and not answering your phone. So we have to have a mechanism for people to rescind that right. What's important is, as your healthcare providers employ thousands of people, you have to give the consumer one way that they are supposed to notify you so you have a defense. That in case, they're not talking to a patient access person, say, oh yeah, I don't want you to call me anymore. Is that person going to know what to do? But at least if it's in a written contract that says, I understand that I can change my mind by notifying, and give them a specific source to call or to email. update@healthcareprovider.com, whatever it is, whatever your name is. The sample wording in these written agreements are really important. I've shared a couple of these with a couple of other clients. They're like, well, we don't need all this stuff. If you have it explained to you after you've read a lot of cases out there, and the cases that are out there today are, boy, they're nitpicky. They're really nitpicky. Here's another place I would put all of these on your patient portal. This is just a client I found on the not a client, it's just a hospital I found on the internet. Put it in your terms and conditions. Yeah, that's the easiest thing to update right now today. Have somebody go and add it to your terms and conditions every time they logged on. Easy spot. So what are collection agencies doing? What are they doing? Well, one of the things that we have in our contract with you, we have the principal agrees to have received express permission from the debtor to communicate in any manner with all phone numbers and emails related to the debtor's account. You're the principal. You're our client. Principal acknowledges and transfers that permission to independent contractor. So most of your collection agencies have some sort of contract with you saying, hey, the phone numbers you're giving us, you should be having express permission in it. So that's how collection agencies are protecting themselves. And don't let that scare you, but we hope that you're doing the right thing. We just need you to take it another step further and get it into written agreements, written admissions agreements. That's really important, really important. As I mentioned before, if you're other type of medical provider, radiologist, labs, anesthesiologist, pathologist, you must make sure that the hospital's contract covers you. You must do that. You've got to do that soon. You've got to make sure. Now, whenever we sign on a client, and if it's a radiologist or a lab, I ask them and I educate, hey, have you looked at your hospital's admissions agreement? Does it? And I would say that easily 70 to 80% of the new clients that we're getting have never heard of the TCPA, don't even know that it exists. And I would say of the hospital's contract, I mean, about 50% of our clients have it in there, written permission, written permission. Gaining new cell phones is important. I want to stress this. 91% of the consumers have cell phones. Make sure that your patient access people are good at asking for cell phones. I notice we don't have a cell phone for you. What is your cell phone with the area code first, please? A simple question. Sometimes people are going to say, I don't want you to call my cell phone. Not a problem. Then make sure you get another contact information or ask again. We ask for cell phones because many people eventually disconnect their landlines, and it saves them the time of notifying us of the new cell phone number. What's your cell phone number? Simple scripting on getting more cell phones. That's important. But a bigger question is where are you going to store these phone numbers and how are you going to store them? Are they stored all in your home phone, the work phone location, or the other phone location? One of the things that we did with our system is we now have 6 different phone locations on our system because it's that complex. There's the husband's cell phone, the wife's cell phone, the husband's work, the wife's work phone number, and then their landline. It's important that software systems become more sophisticated. We're working on an upgrade with our software provider, a phone management tool. It's going to tell us where we got the cell phone number, when we got express permission, does our client have express written permission, did we get it from a skip tracing source, and if so, which one? And once we got it from a skip tracing source, was it a right party so we can determine whether or not our skip tracing services? I think the release of this is coming yet this year, but I'm excited for this new phone number management tool. It's what we need. It's more than phone numbers, though. It also has the capability for emailing and texting, so that if a patient says, you know what, I prefer that you contact me first at email, then secondly at my mobile number, we can determine the priority of how that patient wants their preferred communication channel. Really excited about this, very excited. But we've got to get over this hump here first. This hump is making sure that our clients protect themselves by getting something into their contracts. So when you transfer data to your outsourcing partners, make sure you look at that data file. Now's the time to look back and say, boy, you know what, we've only been sending you the home phone. We've never even sent you cell phone numbers. Here Kenlin is, he's saying, this is going to get you sued, but now I'm saying, we'll send it. You know what? If you've got a good process in place, you're not going to get sued. If you've got a written agreement, you're more or less likely of getting sued. You need to call these people, otherwise you're not going to collect any money, is what it comes down to. You need to call them. So transferring data, make sure the data you're sending is the right data. Look at your system, make sure that the files that are going out. send a piggyback file with the additional data if you need to, a supplementary file. You'll notice that a couple of slides that you've emailed are missing here. I cleaned some of them up with additional data that was newer and more pertinent. So just want to let you know. So more revenue, that's why. That's why you're going to want to send us more numbers. Here's what we do. If you give us a cell phone number, we call it. We believe that you have express permission. We've contacted our clients and said, do you do skip tracing of any kind at all for cell phone numbers? And 99% of our clients don't do any consistent skip tracing for phone numbers. They do it for addresses, which that's no big deal. If we get a number from a data source from skip tracing, so we use all kinds of companies that we use. We use about 6 different skip tracing companies. If we get a number from a skip tracing source, we scrub it to see if it's a cell phone. If it's not a cell phone, we auto dial it with our predictive dialer because it's a landline. If it is a cell phone, we have to manually dial it to get permission. Once we get express permission from that consumer, then we can put it into our dialer. It's less productive, there's no doubt. And honestly, yeah, those phone numbers are dialed less often because it's manual. It's a human being punching the phone number. It's a human being. That's why we need you to get us more phone numbers where you have express permission, and hopefully you're moving towards express written permission in your agreements, because it's hard to reach people that don't have a phone because there's a lot more manual stuff going on. We use a scrubbing service that's integrated into our predictive dialer. Every phone call where we do not have express permission gets scrubbed to make sure whether it is a cell phone or a landline. We use a company called Possible Now. Like I said, and there's no data files. It's integrated. It happens. It runs. It's sweet. So if you're looking to maybe see what's in your system, what % of the accounts you have are cell phones, you can hook up with Possible Now, or we can help you hook up with them. But it's an excellent scrubbing services. Not all scrubbing services are created equal. Like I talked about before, some of them don't tell you whether a landline has been converted to a mobile phone number. Some of them don't tell. The other thing we do is on every call, is this a good number to reach you at in the future? It's as simple as that. That's express permission. So we made an outbound phone call. They pick up. Great. Is this a good number to reach you at in the future? We get verbal permission on every call. We document and add the date. Now, this is a sample screenshot of a dummy account on our system. So every date that we call them, we put the date that we call them and the phone number and the express permission. All I know is that if I'm getting into a lawsuit, I'm going to be protected because I've got the data to protect us. Every single phone call. We audit it to make sure every collector is doing it in every phone call. It's the P35 action code. And we also have a way for them to rescind that. P35R is the action code. So we've created a mechanism for someone to say, you know what, I don't want you to call me anymore. Great, not a problem. We'd be happy not to call you. Just tell us. That's all you have to do. So every call. If our client gets new data, how do you systematically update it with the collection agency? That's the question that I have for you. Some healthcare systems automatically send an update file. I challenge you to make sure that there's something in place within your organization. Or if we, as AmeriCollect, get new data, a new address or a new phone number, how do we systematically update you? We have solutions for this. Just call us. So we have some ideas for you on this. But the question is if I get express permission and I give you that phone number backwards, do you have express permission now? That's a good question, isn't it? So give us a call if you do want some sort of information regarding data going back and forth, whether it's addresses and things like that. We'd be happy to help you. There's a few more things I want to cover before I wind up here. This is where this is at. Wrong number suits. In Soppet versus Enhanced Recovery Company, the Seventh Circuit Court ruled that the consent from a previous subscriber is inadequate, and the companies need to confirm that the person who gave consent still owns the phone number. So let me give you this example. I'm Ken Lindgretz, and my phone number, let's say that at one time I was using Sprint, and I didn't port my number, but I maybe couldn't afford to pay my bill, so the phone number got turned off. and you, as a healthcare provider, have my phone number in your system. I never told you of my new phone number. You turned me over to a collection agency for calling. That collection agency calls that phone number, but now someone else has taken over my old phone number. Wrong number suits. That's what Stop It versus Enhanced Recovery is about. Consumers getting wrong phone numbers. All Stop It had to do was pick up the phone, call Enhanced Recovery back one time and say, hey, listen, I don't know who Kenlon T. Gretz is. I don't know who he is, and I'm not going to pay his bill. Enhanced Recovery makes money by calling people, right parties, not wrong parties. All Stop It had to do was call back and say, you got the wrong number. Instead, it's costing them hundreds of thousands of dollars. That's where this is going to. This just in. The 11th Circuit Court, this is on the same thing. They call this whole thing called party, whether someone's a subscriber or not. So this is a different circuit. It went back and forth twice. It basically said that wrong party calls now will violate the TCPA. At first, it reversed it in Breslow versus Wells Fargo. See, they're suing big people, but they're also suing small agencies, small providers. Wrong parties can file action against you if you dial their phone number. Now, there's solutions out there, but they're tricky. Let's take my daughter, Hannah. Hannah's 19 years old. She could have her own debts. That phone number is not in her name. She is not the subscriber. It's my wife. She's an authorized user, but she's not the subscriber. This is extremely... So what should you do today? What should you do today? Update your agreements, your admissions agreements. I'm not sure if you're in the paper world yet, but if you've got 25 boxes of paper, I want you to look at the cost of that paper versus the cost of defending a class action lawsuit and the amount of time and headache. Throw the old admissions agreements away. Get rid of them. Start fresh. Every new customer, every existing customer needs to fill out a new one today. This is the biggest thing that you need to do. Then what you want to do is to create a TCPA adherence policy that you don't get hit with a willful violation, and educate it with your staff. Educate it that they don't put the next of kin's phone number in the home phone just because that's the only phone number that they have. If it's a next of kin's or an emergency contact, then that's what it is. Then that's what it is. So create a policy that you plan to adhere with it. If you want some help with that, just email me. We can get you some sample policies. Congressionally, the FCC has the power fairly quickly to write some more commentaries on it. And these commentaries can be used in defending class action lawsuits, and these class attorneys know about them. This was a great letter, letter that was written. I think I got this from the American AHAM, I think, American Association of Healthcare Administrative Management. And so it talks about healthcare providers, how we use cell phones. If you want a copy of this, just email me. We'd be happy to get it to you. We need to contact the Honorable Tom Wheeler, who's the chairman, and let him know that the TCPA needs to be updated, and it needs to be updated soon. Get involved with your associations. AHAM has done a bang-up job. They, for the last, 5-6 years, they've been meeting with legislatures over updating the TCPA. We really need to reach out to our frontline, our senators, our House of Representatives, and let them know that this is something that's detrimental to our business. HFMA is another organization that's been doing a good job on this, so reach out. Again, if you have questions, because a lot of them are going to be specific, I'll respond to them. I've got a little bit of a full afternoon here. I'll try to respond to them today or tomorrow. Our next webinar, underpayments, missed payments, or added balances. How do we develop a program to handle these issues? It's all about patient payment behavior. How do we make sure that patients are not robbing Peter to pay Paul? They write you a check for $75 in the month of April. They get your bill in the month of May, and they say, you know what? I'm going to miss that payment. I'm going to rob Peter to pay Paul. Or maybe they are not paying as agreed. They're supposed to be paying $100 a month, but they're only sending in $25. How do you build a program to handle these issues? Or maybe they have added self-pay balances that you need to talk to them about. This is going to be a great webinar Tuesday, August the 12th from 1 to 1:45. Of course, if you have any questions, you can email sales@americollect.com. I want to thank you for joining us. AmeriCollect, we're a 5-time winner of Inc. Magazine's fastest growing private companies every single year from 2009 to 2013. The results for 2014 we won't know until October. We're also a 5-time winner of the Inside Arm, Best Places to Work in Collections, 5 times in a row. Last year we were named #1 in the nation. Happy collectors collect more money, and we've got them here. We're a growing organization. We're about 200 employees right now, and we're working on phase 3, which will allow us to double the size of our office to get to about 400 employees. Grow with us. Help us change the way how consumers view collection agencies using a sales approach to collecting and being ridiculously nice to consumers. Thanks for joining us all, and you have a great Tuesday. Enjoy the rest of the summer.